The legal requirements to create a trust include having the intent to create a trust, someone who's the grantor or the person putting assets into a trust, having a trustee, and then having beneficiaries, the people that benefit from the trust. That typically is all recorded, written down, and then signed by the grantors, and then a notary witnesses those signatures. When someone intends to create a trust, they're generally trying to avoid probate. They do that by putting assets into a revocable trust. That way, when they pass away, the assets can be transferred outside of court. When selecting a trustee for your trust, it depends on your specific situation. If you have minor children, you probably need to look to friends or family members or a corporate trustee to serve as trustee or the backup asset manager when you're no longer able to manage your assets. If you have adult children, people that are responsible, good with money, that you trust, get along well with others, those can be really good candidates to be a trustee. Most people pick their adult children. I personally am a fan of corporate trustees because that can take the pressure off of your family members and minimize the risk of your children or loved ones getting into an argument or fighting after you've passed away. A corporate trustee is really helpful because they take the emotion out of the equation. Assets commonly included in trusts include your real estate, water rights, bank accounts, brokerage accounts, intellectual property. There's all sorts of properties and assets that can be included in trusts. A lot of times when people already have a trust and they're coming to have me check on it, see if it's good or update it, they will have forgotten to update the beneficiary of their life insurance. If you have minor children and the beneficiary of your life insurance is your sister, that is not a good idea. You want to make sure that your trust is listed as the beneficiary of your life insurance. That way, that money is going to go to your children instead of your sister's ex-husband. You should fund your trust after creating it by making a list of all of your assets. Hopefully your attorney will have done that with you during the trust consultation process, but go to each bank institution that you have and move those accounts into the trust. If a trust is not properly funded, it can create a lot of issues. The first one being triggering probate for any assets that are left outside of the trust. The second issue could be having to probate in multiple states. Sometimes people have real estate or assets in multiple states, and if those assets are left outside of the trust, we will be probating in every state where you have assets. If you have questions about creating a trust and the steps to make that happen, contact us at ProvenLaw.